Imagine a high-speed, futuristic car chase.
Oh, sure. Like something straight out of an action movie.
Right, exactly. You picture dodging obstacles, defying physics, maybe, weaving through skyscrapers at just breakneck speed.
Total chaos, yeah.
And honestly, that is essentially the mental image we all have of the current race toward artificial general intelligence.
Yeah.
It's just moving so fast.
It really is. It feels impossible to keep up with sometimes.
It totally does. Keeping up with AI news can honestly feel like drinking from a fire hose. But imagine if that incredible high-octane chase abruptly ended, not with a dramatic crash or some daring maneuver, but simply because the lead car pulled up to a standard, boring red light.
And just stopped.
Just put the car in park and stopped. Yeah. The engine is still roaring, the tech is still completely cutting edge, but a basic, completely mundane rule of the road forces the entire spectacle to a halt.
That's quite the visual.
Right. But that anticlimactic stop is exactly how the most consequential lawsuit in the history of artificial intelligence just ended.
Not with a bang, but a whimper.
Exactly. Not with a massive philosophical crash, but with a literal stopwatch. So, welcome to this deep dive. Today, we are unpacking this massive May 19th, 2026 technology review report.
A really fascinating piece of journalism, by the way.
Oh, absolutely. It details the dramatic conclusion of Elon Musk's lawsuit against OpenAI. But, we are looking way past the flashy headlines for you today.
Right, because the headlines only tell half the story.
Exactly. We are using this specific case as a window into a massive structural clash. The clash between hyper-fast corporate innovation and the really slow-moving legal frameworks trying to contain it.
And that's our mission here. Because while everyone is focused on these two titans fighting, the underlying mechanics of this specific legal ruling are what truly matter for your understanding of the technology landscape today.
Yeah, the mechanics are wild.
They are. We are looking at the structural reality of how rapid corporate innovation interacts with, and honestly, in this case, completely outmaneuvers our existing legal systems.
Okay, let's unpack this by starting with the most unglamorous reality of the courtroom.
The boring stuff.
The really boring stuff. A case involving literally the most advanced technology in human history wasn't decided by a debate over the technology itself.
No, it wasn't.
It wasn't decided by deep philosophical arguments about, the ethics of commercialization or the existential risk of large language models.
Right, none of that actually mattered in the room.
Not at all. The report lays out the immediate facts here. A jury delivered a unanimous advisory verdict against Elon Musk.
Unanimous, that's a big deal.
Huge. And their conclusion was simply that he filed his suit too late. That's it.
Just missed the deadline.
Yeah. This invalidated all his claims due to the statute of limitations. The clock just ran out. And U.S. District Judge Yvonne Gonzalez-Rogers promptly accepted this verdict, which marked just a massive legal defeat for Musk.
It's basically the oldest rule in the legal playbook. Time.
Right. It's like realizing you've been sold a faulty car, but you only decide to check the engine after the warranty is completely expired.
That's a great way to put it. The legal system, it operates on strict, predefined boundaries for a reason.
Sure.
A statute of limitations exists primarily to ensure fairness in standard disputes, to prevent people from holding the threat of a lawsuit over someone's head indefinitely.
Which makes sense for normal things.
Exactly. And it ensures cases are tried while evidence and memories are still relatively fresh. Usually, the clock starts ticking the exact moment a breach of contract or breach of fiduciary duty actually occurs.
Okay, but wait. If AI development moves at the literal speed of light, isn't a standard statute of limitations kind of an outdated concept here?
Well, that's the big debate now.
Because in this specific case, the countdown essentially began the moment OpenAI initiated its highly publicized structural pivot years ago, right?
Correct. The court's job isn't to look at the future implications of a company's technology. The court's job is to look backward at the calendar.
But hold on. A statute of limitations fundamentally assumes the victim, or I guess the plaintiff, knows they've been harmed.
Right, or knows the full extent of the breach at the time it happens.
Exactly. So how can anyone accurately gauge the harm of a foundational shift in an AI company's structure until years after the models are trained and deployed?
It's incredibly difficult, maybe even impossible.
I mean, if the internal mechanisms and the long-term implications of these corporate decisions are just locked inside a black box, the clock is effectively running while the plaintiff is blindfolded.
That's exactly what happened here.
The moment you realize the actual tangible impact of the structural shift, the court just tells you the window to do anything about it closed like 3 years ago.
What's fascinating here is that tension you just described. It is the central paradox of regulating modern technology companies right now.
It seems like a massive loophole.
It really does. But the unanimous advisory verdict and Judge Gonzalez-Rogers' incredibly swift acceptance of it, they underscore a really harsh, unyielding reality.
Which is?
The judicial system prioritizes procedural timelines over theoretical tech debates every single time.
Wow. So they didn't even care about the AI safety arguments.
Not at all. They didn't rule that Musk was right or wrong about his underlying concerns regarding how OpenAI was being managed.
Right.
They didn't rule that OpenAI's current structure is inherently safe or even legally pristine in a vacuum.
They just looked at the watch.
Exactly. They simply ruled that the procedural window to have that argument in a court of law had definitively expired. Procedure always trumps philosophy in that room.
Which means the court didn't say, hey, OpenAI is doing everything perfectly.
Cool.
And they didn't say Musk's concerns are completely invalid. They literally just pointed to the expired clock and closed the door.
That's the justice system for you.
So we have to look at what specific event triggered that countdown in the first place. What was the actual heart of this disagreement that Musk was trying to stop before the buzzer sounded?
To understand that, we really have to look at the foundational evolution of OpenAI's corporate governance.
Right, because he was there at the beginning.
He was. Musk was a co-founder of the organization, present at its genesis when it was established strictly as a nonprofit.
Which is a huge detail.
It's the most important detail. His lawsuit was targeting the organization's handling and commercialization of AI technologies, but specifically, it hinged on their fundamental structural pivot.
The big change.
Right. They transitioned from a traditional nonprofit organization into a highly complex hybrid structure. It's centered around what they call a capped profit model.
Here's where it gets really interesting because we need to break down the mechanics of that capped profit model.
It's definitely not simple.
No, it's not just some casual commitment to make slightly less money than a normal company. It's an entirely new corporate architecture.
Absolutely.
Like a traditional nonprofit is driven exclusively by a public good mission.
Right. The mission is everything.
And a traditional for-profit is driven by generating returns for its shareholders.
Maximize value, yeah.
But this capped profit model attempts this massive structural bridge. It promises a return to investors, but places a strict ceiling on how much profit can actually be distributed.
With the theory being that once the cap is hit, any remaining value just flows back to the original nonprofit mission.
Right. But why does that matter so much? I mean, Musk is a billionaire tech mogul himself. Why did he suddenly become the primary critic of AI commercialization practices?
Well, the nuance of that structure is exactly where the legal friction lives.
How so?
Because moving to a capped profit model, even with a ceiling on returns, it fundamentally reorients the internal incentives of the entire organization.
Oh, right, because you have investors now.
Exactly. The moment you introduce a profit motive and take literally billions of dollars from outside investors, you introduce fiduciary duty to those investors.
Which is a big legal term.
It is. Fiduciary duty isn't just some corporate buzzword you throw around in a board meeting. It is a strict legal obligation.
You're the executives.
For the executives and the board. They have to act in the best financial interest of the entity and its financial backers.
Which changes everything.
Everything. It dictates how fast you deploy products to market, how aggressively you approach monetization, and even how you value your underlying research.
It's basically as if a public library, which you rely on to provide information for the public good, suddenly declared it was now a bookstore.
That's a great analogy.
Right. But to appease the original founders, they promise, hey, we'll only keep the first $100 million in profit and give any revenue beyond that back to the city.
Right. Sounds okay on paper.
But the structural problem is they now have a fiduciary mandate to actually hit that $100 million cap.
Exactly. They are legally bound to try and make that money.
Which entirely changes their daily operations. They now have this overwhelming incentive to push highly addictive thriller novels and expensive merchandise rather than investing in, say, educational textbooks.
All just to satisfy the investors who funded the bookstore transition in the first place.
Right. The fundamental reason for the building's existence has changed.
And that structural change was the absolute core of Musk's grievance here.
That makes a lot of sense.
His argument was essentially that you cannot safely develop something as powerful and unpredictable as artificial general intelligence if the organizational structure is inherently compromised.
Compromised by the need for profit.
Exactly. By the legal requirement to generate a massive financial return, even a capped return, especially when that cap is set at a massive multiple of the original investment, creates immense internal pressure.
Pressure to move fast.
Yes. Pressure to prioritize speed and deployment over caution and open research. Think about it. If a safety check delays a critical product launch by 6 months.
Which happens a lot in AI, or at least it should.
Right. But your investors are demanding a return on their multi-billion-dollar investment.
Yeah.
That fiduciary duty creates a profound internal conflict against the original nonprofit mission.
Which honestly makes this specific legal defeat regarding the statute of limitations so pivotal.
It's massive.
Because by losing on a procedural technicality, Musk's massive critique of this capped profit structure is entirely neutralized in the eyes of the law.
Yep, it's essentially wiped off the table.
Because the court dismissed the case based on the timing, it closed the case in OpenAI's favor. And practically speaking, that validates OpenAI's current commercial trajectory just by default of the expired legal window.
That's the irony here.
Yeah.
The expired legal window cemented their structural pivot.
They didn't even have to argue the merits.
No. They didn't have to win a grueling, multi-year philosophical and structural debate in court. They won a purely procedural victory.
Wow.
And this allows their capped profit model to continue operating, scaling, and taking on more capital without this specific existential legal cloud hanging over its foundation.
So it's a huge green light for them.
It is. The precedent here is vital to understand. Survival in the legal system is functionally equivalent to an endorsement of the business model.
So what does this all mean for you, the listener? I mean, if OpenAI won by simply running out the clock, that implies a massive shift in how tech giants are going to approach regulation entirely.
It's called a paradigm shift, yeah.
It suggests that the ultimate defense for an AI company isn't necessarily having the most ethical technology.
No.
Or even the most transparent safety protocols. It's simply having a corporate structure that evolves fast enough to outpace the legal discovery window.
Exactly. Speed is the ultimate defense.
But let me push back on this for a second, just playing devil's advocate. If tech giants can essentially outpace the law simply by evolving their corporate structures faster than the statute of limitations allows for meaningful challenge, haven't we essentially decoupled innovation from ethics entirely?
If we connect this to the bigger picture, you are hitting on the exact fear that a lot of regulators have right now.
Because if the legal system cannot even process a corporate restructuring in time to properly evaluate it, how on earth is it supposed to regulate the downstream effects of the technology itself?
It's a terrifying thought. We are witnessing a complete decoupling of rapid corporate governance from traditional legal accountability.
Because the law is just too slow.
The law requires time. It requires time to assess damage, to go through extensive discovery phases, to gather internal emails, and to just build a coherent case.
Right, years of work.
But AI companies are iterating on their models and, more importantly, restructuring their financial incentives and corporate shells in a matter of months.
It's dizzying.
It is. By the time a plaintiff or a regulator fully grasps the nature of a structural pivot made in, say, 2019, it is already 2026.
Right.
The technology is 5 generations ahead, and the procedural window to challenge that original pivot has firmly slammed shut.
This creates a deeply concerning perverse incentive for the entire tech sector.
How so?
Well, the strategy for any ambitious, aggressive tech company is no longer to ensure your corporate shifts are legally unassailable from day one.
Right, you don't have to be perfect.
The strategy is to make your corporate structure so incredibly convoluted, like a capped profit LLC nested inside a nonprofit holding company, that it takes external regulators and even former founders 3 or 4 years just to figure out how to legally challenge it.
And by then, it's too late.
Exactly. By the time they draft the lawsuit, the statute of limitations has completely expired. You achieve permanent legal immunity simply through structural obfuscation and delay.
That is a very real, very present danger. And the source material highlights this exact fragility in our current regulatory frameworks.
It's so fragile.
This verdict extends far beyond Musk versus OpenAI. The specific names involved are almost secondary to the blueprint it provides to the rest of the industry.
The blueprint for avoiding oversight.
Exactly. It demonstrates that the safety net of the judicial system assumes a level of transparency and honestly a pace of business that simply does not exist in the artificial intelligence sector today.
It's a mismatch.
A huge mismatch. When you combine highly opaque, extremely fast-moving technology with equally opaque, novel corporate structures. The legal system's reliance on backward-looking procedural timelines just breaks down completely.
This forces you, as the listener, to fundamentally reevaluate how you view the AI tools you integrate into your daily life and your work.
You really have to change your perspective.
You cannot assume that because a company is operating openly or because they haven't been successfully sued, that a court has rigorously examined and approved their internal structure or their safety mandates.
Definitely not.
The regulatory safety net has massive structural holes in it, created entirely by the sheer speed of technological and corporate advancement. You just can't assume someone in a courtroom is looking out for your best interests.
Because they're looking at a calendar.
Exactly. They're looking at a calendar, not the code.
And honestly, this transfers a massive burden of critical thinking directly onto the consumer and the enterprise user.
Which is heavy.
It is. If regulatory frameworks are inherently lagging, then public understanding of these corporate structures becomes our primary defense mechanism.
Knowledge is power here.
Exactly. Knowing the difference between a genuinely mission-driven nonprofit and a capped profit entity that is strictly bound by fiduciary duty to investors, that fundamentally changes how you should evaluate every press release they put out.
Every product launch.
Every single product launch, and every safety claim that company makes.
Yeah.
You have to evaluate the incentives behind the tool, not just the outputs of the tool itself.
Okay, let's bring this all into focus as we wrap up. We started this deep dive looking at a massive piece of AI news from the Technology Review, isolating one specific, highly consequential courtroom decision.
The Musk versus OpenAI verdict.
Right. We looked at a missed legal deadline, a unanimous advisory jury verdict, and a judge's swift gavel. We unpacked the core structural conflict that triggered that countdown in the first place.
The monumental pivot from a nonprofit to a commercially incentivized capped profit model.
And all the intense fiduciary duties that come with it. And finally, we arrived at the ultimate reality here. The perverse incentive created when the slow procedural mechanics of the legal system utterly fail to catch up with the warp speed evolution of corporate governance in the tech sector.
And that reality is going to shape the next era of tech. The corporate structures that manage to survive these initial legal battles, whether they survive through actual merit or just through procedural technicalities, those are the structures that will dictate the architecture of our future.
The safety protocols, the commercialization, all of it.
Yes, they will dictate the AI systems that define the next decade.
This truly is the invisible architecture of our future, and we really want you to keep questioning the internal frameworks and the financial incentives behind the technology you use every day, because, as we've seen, the courts are simply not equipped to do it for you in real time.
This raises an important question, something we really want you to consider as these models become more embedded in society. If the legal window to challenge foundational structural changes in AI companies has already permanently closed for their very own billionaire co-founders.
Wow, yeah.
Who in society will actually have the legal standing and the pristine timing to challenge the next massive unforeseen shift when AI inevitably evolves again?
That is such a heavy thought, and that is exactly the thought we will leave you with today. If the co-founder with infinite resources and a literal army of lawyers can't beat the procedural clock, where does that leave the rest of us in demanding transparency and accountability? Thank you so much for joining us on this deep dive. Keep questioning the frameworks, keep looking at the incentives under the hood, and we'll catch you next time.